In this episode, I'm talking with Anna, Global Senior Data Privacy Lawyer at Dentons. If you want a blueprint for implementing AI safely and strategically, this conversation is essential listening. So Anna, talk us through the process of implementing or adopting AI from your kind of standpoint. Where do you start? What do you look for? What is your thought process and the frameworks you kind of use to do this?
So we have a dedicated innovation team that makes like the first steps. So let's say that I'm starting from the point that we've already chosen the model. So if we chosen the specific AI model, then I'm drafting privacy impact assessment or data privacy impact assessment. Generally under the GDPR, there is no such clear requirement to draft a data protection impact assessment, but I would recommend it because it basically contains all the points within under UCMI law. There is a term like privacy impact assessment, which is not this one that is required, but still includes all the points. Why it's so important? Because within the data protection impact assessment, you are basically assessing all the risks that are involved with the AI tool. So you need to assess firstly in terms of data residency, whether there are any data residency requirements under the law, whether the data needs to stay, for example, in Europe, in UK, or in Canada, whether it can be sent to US, for example, or not, what kind of tools, measures you need from a compliance perspective in order to allow this. So these kind of things are included in the data protection impact assessment. Very important element of data protection impact assessment, which I am starting very often from, is the architectural diagram. So you basically need to understand what models are used by the company, because it's very often the situation that a couple of AI models are used. So where they are based, what is the data flow between these models, whether the data are encrypted. You need to establish whether there is an encryption, so-called in transit, whether the data are encrypted when they flow. As well as whether there is an encryption at rest when they are processed, even ephemerally, right? Because the processing is only for the time to create the output, basically. So the process is not very long one, but still it could create various risks from various perspectives. So you need to understand like the whole data flow, what kind of models are utilized. Then you need to also answer the question whether you would like to use your database and connect your database in order to enhance the results, to have a more adjusted result to your needs. Then you need to talk with your IT department if you have. If not, like you need to think about that you need to have a database that is also protected and somehow connected, integrated with the AI model. What are the risks related to this connection? Because the benefits for sure are there, because for example, hallucination effect is minimized when you have connected so-called retrieval augmented generation database to the AI model, because the model does not give you the answer that it's most probable. If something is not contained in the database, it just won't hallucinate. So it's very useful to answer this question. Next, you need to think about the retention period. How long the data will be processed within the model, how long it will stay in the chat. You need to, in order to determine from a privacy perspective, you need to go through the process of so-called legitimate interest assessment. So basically you need to assess what are your legitimate needs to keep the data within the chat, whether you need to keep the data, or maybe you need to also keep the documents that you uploaded to the AI model. These kind of things you need to determine, establish during the operational process, before using the tool, right? Retention period is also very important. You need to know also what are the other security measures, whether the data is not only encrypted, but maybe there are certain flows that you need to protect specifically. So this is why from a security perspective, is always very important to analyze in detail what is going to happen with the prompt.
Each week, I take what I'm hearing in conversations with legal leaders. I analyse the market and track emerging trends in this AI era. In my newsletter called The Future Lawyer Market Intel for the AI Era, I'm focused on what AI is exposing, the opportunities, the blind spots, and the shifts shaping the next 5 years. This is how you see the chessboard before everyone else does.
Apart from a privacy perspective, which is somehow connected, we are always checking the documentation, right? So you need to make a decision whether to enter into the data processing agreement or not, whether you will be processing personal data or not. If you will be, you need to conclude the DPIA. If you do not need to, you feel that you won't be using personal data, I would still recommend to conclude data processing agreement, just in case. You don't know whether your lawyers, if you are a managing partner, you don't know whether they are actually, something like this could happen. Then you need to protect your data and your personal data. So you need to review the data processing agreement. Yeah, I think that's the most important things. Of course, you need within the data processing agreement, you need to check whether the vendor will be using your data to train the model. Obviously, you don't want to do this, so you need to have a certain warranties in contract in order to forbid such usage. This is applicable to the vendor as well as to any subcontractors. From a privacy perspective, they are called subprocessors, right? So we need to also ensure that subprocessors won't use your data to train the model. So you need to think about warranties as well as some additional clauses that will protect your data in a specific way. You need to think about the liability. You need to check whether from an IP perspective, intellectual property perspective, whether the vendor will defend you in case of any claims, because the situation is it's like a SaaS solution, so it's software as a service. So it is very often the situation that the vendor will be responsible for the AI model, right? So you need to ensure that this kind of clauses are included, and like very huge vendors, even Microsoft is offering such warranties. So you need to check what you need, if something like this is offered, what in exchange, what is your obligation to implement certain capabilities to protect your data and to have this warranty still in place, right? So you need to check the documentation that is available. Everything from that is available from the vendor, you should ask from a privacy, security, and from a general like legal perspective. Of course, like this seems to be very burdensome process, so you need to somehow adjust. But like I believe the most important parts are privacy impact assessment, data processing agreement, checking security measures, know what is the flow, and obviously where the data will stay, because otherwise you won't be probably able to use it if it's not allowed under your jurisdiction. From my experience, it is also very often the case that if the vendor first does not offer the so-called data residency, so that the data will be processed in one region, you could ask the vendor whether this actually could change in the near future. And from my experience, very like huge vendors from a legal industry, they have implemented certain changes in an IT architecture in order to allow processing within the, for example, European Union, because that's one of the requirements.
Wow, yeah, it's a heavy process.
True. But like I would really recommend it because it's confidential data. Lawyers have a lot of obligations, professional obligations that they need to follow. So they need to be aware that confidential data, clients' privileged trade secrets, every sensitive aspects of the data could be disclosed when using AI models. So in this case, you should really like think about these things.
Absolutely. And I actually did a poll on LinkedIn asking lawyers, what is your biggest concern about using AI in your work? And the options were like things like replace your job, not having enough training, and the one that got the biggest percentage of votes was on data protection and privacy, concerns around AI, I guess, disclosing data or using the data that you put into it and giving it to someone else, in and it's really fascinating how this is the biggest concern that lawyers have. And I guess it's the biggest thing because they're ultimately liable and there's so many consequences around that. So I think you're right in saying a focus on that is so worth it, even though it's such a big process.
Yes, and you mentioned training. Training, obviously, when you already implement it, like the next part is also crucial, because you need to think about so-called operational readiness, right? So you need to implement the guidelines, policies, because like implementation is one thing, but you would like to actually start using it, right? So you need to think about the guidelines, do's and don'ts, what to do, what to not to do. You need to check the client terms, whether certain clients are actually not forbidding, for example, usage of AI tools. Unfortunately, this is very often the case. So you need to have a list of clients that do not forbid, and like inform your lawyers and maybe implement in the AI tool some information, some pop-ups, so that they will not upload any data related to these clients. And finally, you need to think about the training, because again, like implementation is one thing, but you need to start using it in a very accountable way. So in this case, you need to provide a training, and then you need to think about whether you would like to differentiate the training depending on your needs. So whether for junior lawyers, there should be some kind of different training to like focus on the things that they will need to do and how they will be using the tool, and maybe other training for them for older lawyers that will be using it in a little bit different way. Maybe you will be implementing the tool that will be used by some business departments. So if it's like a bigger law firm, then you need to maybe focus on the business focused training. You need to really explain lawyers or other people how the tool should be used, how the prompts, so the input should be formulated in order to achieve the desired results. From my experience working and gathering feedback from lawyers, it's very often the case that the tool has been implemented, but they don't know actually how in practice it could be used. So training is very essential.
I definitely agree. I was actually speaking to a lawyer who said there's so much focus on AI governance within companies that they're actually forgetting the operationalization and actually showing lawyers how to use the tools and actually putting in structures and policies as to how to actually implement the AI, because they're kind of so distracted by everything that you've just mentioned, I guess. But I think both of those things in balance are equally as important as the other. Otherwise, you just kind of stagnate the process, right?
Exactly. Like without the proper training, the tools are useless, right? Because even when starting thinking, you need to think about what are your needs, right? So, what kind of tasks I would like to use the tool for, whether it's okay to use it. Like very often the vendors offering the usage of the tool for the only trial period. So it's very recommended to use it if you have a proof of concept, use it for a 3 months, 4 months, check it whether it really meets your needs, and then starting actually implementing it, right? But even remembering that even for this very short period, you need to actually go through at least the most important part of the process if you would like to, again, upload some data, some client's data, some personal data. You need to be basically aware of your limitations.
Yeah, that makes sense actually. Going through like a trial period and just seeing how it goes before going through that massive process of actually assessing the AI and going through the personal the data protection and privacy requirements and risk assessments and all these things. Before going into all of that, make sure you actually want to use the AI.
Yes, exactly. And so the usage is based on the license for model, right? So you need to actually spend and think about like how many licenses you would really like to use it. So then you need to think about the group of the people that will be dedicated for this usage. So yes, that's crucial.
Let's say then you are approached by an AI vendor, or you're looking to get some type of software to use internally. Before you even speak to that AI vendor, what do you have to have clear internally? Yeah, what do you have to have clear internally in terms of what you want from that AI vendor, or what you can actually accept into the company? And what goes wrong if you don't arrange that, whatever that thing is that you need to decide internally before adopting AI?
Yeah, very good question. So firstly, yes, like how I already a little bit mentioned, so about it is you need to think about your needs, like how you are going, for what purposes you are going to use the specific AI tool. Whether you would like to use it for drafting contracts, due diligence, specific, maybe you have a specific clients that actually ask you for a research that will be so huge that actually the tool will help you to do this. Like from my experience, it's also somehow driven by clients, by certain clients and certain work. So you need to think about your need. Then you need to think about specifically like some laws, limitations. So basically, what maybe there are so-called data localization tools, rules. So in this case, the data needs to stay within like some countries. So if you are like a global or regional company, you need to think what is the situation in terms of geographically, whether there are any limitations. You need to think about the various AI acts that are adopted in many countries. Of course, we have now in Europe, but there is a very strict one in South Korea now adopted. So basically, you need to think about different laws that could be applicable from an AI perspective and what kind of limitations are connected with these laws. Because maybe like in Europe, you cannot use it, or you don't want to use it for HR purposes, because then you are follow under the definition of high risk, and then you have a lot of obligations connected with the implementation of the AI tools. So data localization laws needs to be taken into account. Of course, like what I mentioned about the client consent, right? Sometimes the clients do not just prohibit usage. Sometimes it is required to acquire consent from the client before usage. So you need to check the client terms, basically. What are the limitations if you would like to use across various cases? Also, geographically, for example, if in US, American Bar Association has issued guidance, it was like 2 years ago already, and they mandated lawyers to firstly ask clients whether the AI tools could be used. For now, at least, in UK and in Europe, there is no such a requirement, but yeah, like implementing in US territory, you need to think about these things as well. In Europe, you need to think about so-called AI literacy. So AI literacy is basically training. So you have regulation within the AI Act, an obligation to provide specific training. So you need to also spend some money for this. So you need to take into account in your calculations. So I think, yeah, these kind of things are the most important even before approaching vendors. Of course, you need to then check what are the market offerings, and then, choose whatever is best for your needs. But yeah, these kind of things are, I think, prior initial
Wow.
assessment.
Again, it's a lot to consider, isn't it?
Yes, of course, like it's a complicated process, but we need to think about it from a perspective that AI tools are just not like simple softwares, right? There are many amplified risks connected with these tools. Like firstly, you will be your lawyers will be uploading a lot of data there, a lot of confidential data. There is a problem of hallucination. So you need to think about maybe this RAG technique if you would like to use it. You need to think about this security measures. You need to protect it specifically. This is why you need to think about client requirements because of these amplified risks that it brings. So basically, a lot of things you need to go through, but then you will feel more confident when using it. So I think it's worth putting some effort here.
What would you say are the worst case scenarios if an AI vendor is not properly assessed around data or client confidentiality?
There is a term in these situations, we have a so-called shadow AI. So basically the AI tools that are used across various firms, but of course also in law firms, that have been not properly assessed but are still used because are available within the company networks. So in this kind of cases, it's very risky to use it because firstly, if you have not assessed it properly, if you have not onboarded, not concluded a contract with the vendor, then everything what you are put there, you can assume that it could be revealed and disclosed everywhere. Why? Because each huge AI vendor is retraining the model sometimes per year, once per year. This is the case with OpenAI, as I have heard, sometimes once per 2 years. They are doing it in order to enhance the methods, to improve the results, and they are using all the customers' data. There are no limitations. This is why when you are implementing it in your company, you would like to have the warranties that your data will not be used to train the model. Because otherwise, if you are include anything from your client, it could be disclosed to another lawyer somewhere else, right? So you need to have, for this purpose, at least data processing agreement. Sometimes, and some lawyers are saying that it's enough because basically within the data processing agreement, you are regulating that the vendor will act only upon your instructions. So it means that they cannot use it for their own purposes. Obviously, retraining is own purpose. So without this DPIA, they could use it. So it's sometimes sufficient to have the data processing agreement in place, and then you are covered. But without this, I think that's the most obvious and most harmful way, which is certain. Less certain are the security attacks. They happen very quite often, couple of years, like a couple times per year. OpenAI has been attacked. Other AI vendors, there was a huge AI related attack in Singapore, as I remember last year, and real estate contracts from governments have been impacted. So a lot of personal data have been revealed. So obviously this kind of attacks happen. There is a so-called OWASP top 10 risk for AI applications. This document, from a security perspective, has been drafted because of the very new and sophisticated security attacks that could occur in connection with the usage of the AI models. There could be like a prompt injection. So whenever you are drafting a prompt, your prompt could be changed and it could be added something that it's not visible for you, and then it could be shown in the output and your data could be stolen in this way or changed, and you will not even notice this. So a lot of different security attacks are happening. They are more and more sophisticated, and the most often situation when they are occurring are in case of the simple situation when you do not have a business contract, but the data is available everywhere. So I think the second point, very important point, are the prevalent, I would say now, security related attacks on these systems.
Yeah, you're right. You don't know when they might happen, or it's very unpredictable and risky for sure. And I think lawyers, most of them are concerned about what you've basically just mentioned, the fact that AI could affect, lose, or disclose client information, which is just such a huge risk for the reputation of a firm, but also for liability purposes. So it's massive. But what would you say? Because obviously, I appreciate that you work for a huge organization, and there are probably people listening who are from smaller firms or even medium-sized firms where they don't have big teams to assess data, but they want to use AI. Is there any kind of, I guess, ways around it, or what can those guys do, or is it literally just follow the process that you mentioned?
Like, yeah, it would be the best way is to follow the process, but obviously, like, at least what I would say is to enter into the data processing agreement, because then you will protect your data and pay for the license, right? Because the business licenses that are prepared for businesses are more restrictive and more protective for the businesses. So that's the first thing. The additional thing, because you will need to answer the questions about the consent from the client. I believe that even if you are small, you are aware that you cannot sometimes use it. But think also about the retention period, because this is something that you could really shorten in order to minimize your risks. It does not cost you a lot, but it could bring you a lot of benefits in case of any attack, any security related attack. So yes, enter into data processing agreement, think about the retention period, conclude the contract. Like, if you have like the warranties, please check the warranties, whether your data will be used for training or not, just to be sure to have it clearly stated by the vendor, right? These things are very important. And like, secondly, yes, think about like the policy, at least implement one policy in your company related to usage of artificial intelligence tools, acceptable use policies, right? They are called like this very often. So implement one policy and state there like how you would like that the tool, different tools to be used in order to minimize the risks. Yes, I think that's the most important things.
No, that's super helpful. Thank you. Thank you for that. I think it's really important to know as well, because I think so many lawyers, employees want to use, ChatGPT or Claude or something like this. And I know that many law firms don't even have an AI policy, and it's kind of very, very risky. It's like a wild west, They don't know what's right, what's wrong, and from what you're saying, there's huge risks involved with this.
Exactly. So this is like, yeah, this is why the policy will include there like how the tool should be used, what not to do, whether that you need to check the client terms, right? Like, these are the points that could really save you from any bad situation that could happen. Strongly recommended.
Yeah. How do you think then firms can think differently about AI vendors if they want to balance innovation with governance and data protection and risk assessments? Because you've mentioned a lot of procedures and frameworks that companies or law firms can use to assess, the safety of AI. It kind of makes you think, well, are you kind of cutting innovation, which, is also important? So how do you think firms should be looking at that?
Basically, you need to think how you would like to use, so what are your needs, how you would like to use the tool. So about this innovation aspect is very important. I strongly, like, in general, I strongly recommend usage of the AI tools. Like, people should not be aware to use it because it's very useful. I'm on a daily basis using it. So these innovation needs, as you mentioned, like, are very important. But to balance it with all the obligations that I mentioned, you can think about it from a perspective that, all right, that will be the tool that will be used for the specific purpose, but I just want to protect it to the extent that I can. So, for example, in addition to what I said, you could also implement some anonymization tools, because, for example, like a specific tools that would anonymize the data before the data will go to the AI model. because you would like to use it for a specific purpose. But maybe for your usage, you do not need to upload personal data there, right? So you do not need to then think about like anonymization. You do not need to check specific, or you maybe can implement longer retention period and keep the data in the chat for a longer period. So depending on your needs, you will need to think about different situation, different points that could be tweaked a little bit in order to meet your needs. For example, within the data processing agreement, maybe you have an option to use it not in every place if you are like a global company, but you do not need to use it in a certain locations. You do not need to enter into the transfer clauses. Then your negotiation process will be just simpler. Maybe you would like to use it only for business purposes. Then you do not need to think about maybe or like focusing on the retention periods. So depending, like sometimes if you do not need to use your own data because it will be used by the people, like let's say from the business purposes, maybe you would like to just automate certain tasks. So then you do not need to conduct the whole data protection impact assessment, but basically just check whether the data is used only within the closed infrastructure and it's separated from other clients within the cloud. And sometimes it will be just sufficient to think from these perspectives. But everything would depend on the needs, because the amplified risks are there. You are processing a lot of data. You could be uploading everything there. So there is a risk of bias, there is a risk of hallucinations, and bar associations in every country now are emphasizing that it shouldn't be used in not responsible way. You should really at least focus on the main points. So you can always think about like balancing innovation, but like you need to think about this protection. That's your legal obligation, not only legal but professional obligation. Each lawyer in each country has been trained that we need to protect clients' data, and we need to still have it in mind, and we just like cannot forget about it because we would like to be innovative. That's the same obligation that's been from the very beginning when we started. We've passed the exams, and that's something that we should be always having in mind.
I think there's some fantastic tips and points there for sure. I think you've really got a kind of a big picture view in terms of how things should be, and I think it's fantastic, and I think people are going to find it super helpful. So thank you so much for that, Anna.